Hello, everyone, and welcome to the latest chapter of our criminal litigation series for those who are studying the bar practice course or just the general public who are looking to just get a better insight into the criminal justice system. Thank you, everyone, for watching the previous videos and subscribed. Helps for people to subscribe just to increase the scope of the channel, and I'm very grateful for those who've done that. And if you haven't done, then if you can like and subscribe, that would really help. So today we're looking at chapter 2 of the criminal litigation elements of the bar practice course, and this looks at police powers. The previous episode looked at an overall overview of the criminal litigation segment of the bar course, and now we're going to move on to some of the more detailed content. You may also like to know that there is a YouTube Shorts video on PACE, and we are going to cover PACE in this episode. It's a quite a short and snappy overview of what the police can and can't do when they look to arrest someone. So head over to the YouTube Shorts section to watch that video. I'll put a link in the comments below. So police powers sit at the heart of the criminal litigation element of the course, and the Police and Criminal Evidence Act 1984, better known as PACE, of conduct and codes of practice, exist to balance two goals: effective investigation and also the protection of the suspect's rights. So in this masterclass, we will walk the journey from arrest through detention, interview, and also the charging decision. As future advocates, you must be able to test each stage. So was the arrest lawful? Were rights respected? And is the evidence reliable? So under section 24 of PACE, a constable may arrest without a warrant if two requirements are satisfied. The first is a reasonable suspicion that an offence is being or is about to be committed. And secondly, necessity under Code G. Suspicion alone is not enough. For those of you who watch different types of YouTube videos, you probably see I did do a video on auditing, and some of these auditors do stand outside police premises or just in the general public and see what level of interaction or what response the police give. So suspicion alone of any activity is not enough. You need reasonable suspicion that an offence has been or is being about to be committed for an arrest to take place. Just a reminder, this is not an in-depth revision session for those in the bar course. It's just a general overview, just so you've got a snapshot on the key areas that are covered within the syllabus. So a lawful arrest requires stating the fact of arrest, giving the grounds, including the necessity reason, and also giving the caution at the earliest practical moment. So head over to the YouTube Shorts video, and I did quote the full caution that an officer needs to provide the alleged defendant. The full Code C caution must be used if the suspect is not told why they are being arrested or not cautioned properly. The arrest may be open to challenge. Under section 117 of PACE, officers may use reasonable force where necessary, necessary being the key word here, to exercise a lawful power. Reasonableness is judged on necessity and proportionality, based on the facts as the officer honestly believed them to be. Excessive force risks civil liability, disciplinary action, and also evidential consequences. So You may have seen some clips previously where the police officers deemed to have used excessive force, and the Police and Conduct Authority generally investigates those situations. So excessive force risks civil liability, so a civil claim can be made if that does occur. After arrest in custody, so at the station, the custody officer becomes the key safeguard. They must authorize the detention, open the custody record, and also ensure the suspect receives their rights in writing with access to the PACE codes. It's at custody where procedural fairness either begins well or it starts to begin to unravel. And the time in custody, there are detention time limits, so know these limits clearly. The clock starts at the relevant time, and this is usually arrival at the first police station. There are a number of key hours to look up in your syllabus. This is up to date as of 2025 time of recording, but generally up to 24 hours detention without charge, up to 36 hours superintendent extension for indictable offences. Have a look back at the chapter 1 video on summary and indictable offences if needed, and then up to 96 hours whereby a magistrate can extend for indictable matters. Also remember, terrorism detention is separate and significantly longer, so there's separate rules for terrorism. Interviews are governed by Code C and Code E of PACE, and the suspect must be cautioned. The interview must be recorded, and the right to silence and right to legal respected. Adverse inferences under Section 34 of the Criminal Justice and Public Order Act 1994 arise only where the statutory conditions are met. They do not replace the need for a proper prosecution case. So just remember, key elements for this are the suspect must be cautioned and the interview must be recorded. And the defendant, whether that's on advice from their solicitor, can have the right to remain silent. We will look at adverse inferences from that on a future episode, but just remember that for now. And also the right for legal advice, whether that's access to their own lawyer or someone to be appointed for them to act on their behalf. So the key rights, just to summarise, include legal advice under Section 58 of PACE, having someone informed under Section 56, and written notice of rights. So these rights are not optional, they are core safeguards for the defendant. So what about under 18s then? So under 18s and mentally vulnerable adults require an appropriate adult to support them. And also an interpreter can also be required. So where language is a barrier, a qualified interpreter must be provided. It's important that understanding is not lost. Otherwise, the interview must pause. Someone's livelihood and also their liberty is at stake. So we need to make sure there's no unfairness in the process and they fully understand what the officer is putting to them. So what about charging then? So the CPS, the Crown Prosecution Service, applies the full code test. So firstly, a realistic prospect of conviction. They'll look at all of the evidence available to them. And secondly, the public interest test. So is it in the public interest to charge the individual? Where evidence is incomplete, the threshold test may apply in some limited situations. But as a general rule, it needs a realistic prospect of conviction based on all the evidence at hand, and also it needs to be in the public interest. So what about starting proceedings? So proceedings are commenced by the charge, which we've just mentioned from the Crown Prosecution Service, And that can either be a written charge or a requisition or information laid before magistrates. So that's just a whistle-stops tour, I should say, and summary of the process from arrest to charge. So we've gone from arrest to custody to interview and then to charge. It's important to remember that the process must remain fair, lawful, and accountable. And the key thing here is under the PACE and its codes at all times. So I hope you enjoyed that video. As I said, it's just a brief whistle-stop tour of the police powers and PACE, and also the initial parts of the journey for a defendant once they've got arrested all the way up to charge. On the next episode, we're going to look at the first hearings that a defendant may attend. So don't miss the next lesson. Hope you've enjoyed it. If you have got any questions on the content provided in this video, just drop a comment below and I'll try to answer it. But thank you again for watching. I do hope you do like and subscribe. It does help grow the channel. But I hope to see you on the next episode, and it's bye for now.